As discussed earlier, law is basically divided into two categories: public law and private law. Under public law, there are different branches. Number one, public international law. Number two, private international law. Number three, constitutional law or national law or municipal law or domestic law. Number four, administrative law. And number five, criminal law or law of crimes. What are these branches? What they deal with? We had already discussed. Now coming to the other branch of law is private law. Private law, there are so many branches of private law. Private in the sense contract, law relating to contracts, law relating to carriages, transfer of property act, family law. Other than these public laws, the remaining are private laws. Now, an important thing is if the public wrongs are tried in public wrongs or crimes or offences are tried in criminal courts, whereas private wrongs are tried in civil courts. Now we have to discuss about some other important aspects. What is general law? What is special law? What is general? So you know, law or legislation or enactment, all or statute, all come within the same meaning. Depending upon the situation and time, we call statute or legislation, law, act, like this. All are synonymously used. Now, what is general law? What is special law? You know, Indian Penal Code is general law. Criminal Procedure Code is general law. Indian Contract Act is general law. Like that, they are the main law. If a particular branch of law is codified by central legislature, it is main law or general law. But special laws are there. For example, Indian Penal Code is main law or general law, but Dowry Prohibition Act, Prevention of Corruption Act, Adulteration of Food Essential Commodities Act, TADA Act, terrorism, acts relating to prevention of corruption, acts relating to prevention of drug addiction, all these are special laws. What is the purpose of these special laws? For example, the dowry prohibition, dowry death is there. There are relevant provisions are there in Indian Penal Code, and relevant provisions are there in Dowry Prohibition Act also. If a case is filed under relevant section of Indian Penal Code in an appropriate criminal court, it will take much time. Suppose if this dowry death case or is filed in a special court, that is the family court. So general courts are there, municipal magistrates courts, session court of session judge, court of district session judge, first class magistrate, chief judicial magistrate. Like that, there are criminal courts are there, from lowest court to the apex court, that is the Supreme Court of India. But however, the special courts also are there. The very purpose of special courts is to clear the case at the earliest possible, for speedy relief and speedy disposal of the case and quick relief. In order to provide quick relief to the aggrieved party, these special courts and special legislations are passed. Suppose a woman, an aggrieved woman is there, a married woman, she is aggrieved by, she is harassed by husband, father-in-law, mother-in-law and other collaterals. The harassment may lead to death or something. So the case, if the case is filed in general court, in district sessions court or magistrate court, it will take much time. If the case is filed under Indian Penal Code, it is different. If it is filed under Dowry Prohibition Act in a family court, the case will be decided quickly. The aggrieved party will get the relief quickly. For this purpose, for speedy trial, for special trial, these special laws are made, and Indian Penal Code is main code, but there are so many special legislations. Special legislation. This is what you have to keep in mind. Special law and general law. Now, in our today, the purpose of delivering this general lecture, which is useful, very useful to all law students, right from first year LLB to final year LLB, whether it is 3-year course or 5-year course. But we are completing law degree, we are getting through examinations, but basically we are not able to know some important topics or burning topics in the. Suppose when this particular important topic or burning topic is discussed in court or in institution of legal studies, if we do not know, if the discussion takes place on this particular topic, if you express your ignorance about that particular topic, you will become, you will be looked down before the other members of the law. So that is why, what is Locus Standi? What is public interest litigation? What is writ? What is writ jurisdiction? What is judicial review? What is judicial activism? What is doctrine of separation of power? What is rule of law? What is delegated legislation? This type of concepts, every law student, every law graduate, every law student and every law graduate is expected to know. When that particular concept is discussed, if you express ignorance, you say that what is that, I don't have any idea. If you speak like that, you will be insulted. So that is why I sincerely suggest my student friend to be cautious. As a law student or a law graduate, you are expected to know some burning issues. Here, now one thing is organs of the government. Organs of the government. So there are 3 organs of the government. One is executive, second one is legislature, and the third one is judiciary. What is here? Executive means in a cabinet form of government or parliamentary form of government like India, the executive initiates any law, and further, suppose there are some areas in India. Some branches of law are not codified. Law of torts, administrative law, environmental law. But environmental law as a whole is not codified, but there are more than 200 legislations on environmental law. But there is no main code, main act on environmental law. But in environmental, there are so many acts. But that is why we can say that it is not codified as a whole. There are so many piecemeal legislations. Air Act is there, Water Act is there, Wildlife Protection Act is there. Like that, so many acts are there. Out of more than 200 acts, 14 acts are more important from examination for LLB studies. Here, what is, suppose the main purpose of executive is to initiate law. In order to initiate law, suppose law of torts is not codified. There is a demand to codify the law. So I told you in the last class, what is codification? If the principles of law are well defined and systematically arranged in a code or text, that process is called codification. If the principles of law, particular branch of law, are systematically well defined and arranged in a particular code or text, it is called codification. Indian contract is codified, Indian Penal Code is codified, Indian Evidence Act is codified, Transfer of Property Act is codified, Criminal Procedure Code is codified, Civil Procedure Code is codified, Limitation Act is codified. So many acts are codified. So that is why when the particular branch of law is codified, we say that part 1, part 2, lecture, chapter 1, chapter 2, schedules, so all these things are there. Suppose if any branch of law is not codified, there is no any SPAC. Suppose the Constitution of India 1950 is there, but the administrative law is not there because the administrative law is not codified. Environmental environmental law is not codified as a whole, but so many small legislations are there, but as a whole it is not there. So that is why the purpose of, with reference to law making, earlier when any particular branch of law is to be codified, there is a demand for codification of so many laws, but due to so many technical and practical problems, our government or legislature will not be able to think about passing of that particular law. For example, law of torts is not codified, government liability is not well defined or codified. Then similarly, when government is liable, when government is not liable, that is not codified. The principle of basic structure is not well defined or codified. So there are so many areas in India. Laws are not today. There are hundreds or thousands of legislations are there. These legislations passed by central legislature, that is parliament, state legislature, and subordinate authorities also. Laws are passed. But ultimately still there is a deficit of certain laws in certain areas. That is one thing. In certain areas law is not clear. So for suppose any law is to be codified. Suppose Indian Companies Act was passed in the year 1956. When it was there is a consistent and unstinted demand for revision of recodification of company law. So many things, so many developments took place. Ultimately, Indian Companies Act was again recodified in the year 2030. So like this, when a law is to be coded, there is a demand that proposed the demand should go to the executive. Executive in cabinet form of government is Council of Ministers headed by the Prime Minister. Council of Ministers headed by Prime Minister is executive in central level. Council of Ministers headed by Chief Minister, followed by Governor is executive in state levels. Here Parliament headed by Prime Minister and followed by President of India is executive here. So here President is ultimate head in the three organs: executive, legislature and judiciary. For any executive action, ultimate authority is the President. For legislative action, ultimate authority is the President. For judicial action, ultimate authority is the President of India. Now coming to the technically he is the highest, and practically the Prime Minister will play crucial role. Now any law is there is a demand for codification of any branch of law. First of all, the demand will go to executive. Executive immediately will think it of. When it responds in affirmative, a proposal to that effect is sent to the Law Commission. So the codification process took place with the appointment of First Law Commission. Under the First Law Commission, Indian Contract Act, Indian Penal Code and some other legislations were passed in the year 1872. Subsequently, Second Law Commission, Third Law Commission, as and when there was a need to codify any particular branch of law, law commissions were passed. As time passed, population is increasing, litigation is increasing, socio-economic changes are getting changed. We are very witnessed tremendously. So ultimately, permanent law commission was constituted. So when any law, if there is a demand from public for passing of any law, then the proposal that it should the cabinet will decide, will take decision to codify that particular branch of law. A proposal to that effect will go to the law commission. Then law commission will appoint a committee. One person, one distinguished member of law, maybe High Court judge or Supreme Court or any jurist or any law professor, the outstanding distinguished law professor may be appointed as chairman, and some other members, lawmen will be appointed, and the law commission will constitute a committee. They will go in detail with the codification of that particular branch of law. They will take so many steps. They take the what is if the similar branch of law is codified in other countries, they will take the help, and some other similar laws also they take into consideration, and what are the provisions that are to be incorporated in that particular branch of law will be critically examined, and opinions of the experts also will be taken, and ultimately they will complete the draft on the bill, and the bill will be sent to the submitted to the executive. Then executive will, after approval, will send that bill proposing the codification of law, passing of an act. Will go to it is that bill to that effect is presented in Lok Sabha. Lok Sabha, after when the bill is discussed, a 2/3 majority of Lok Sabha we have to two-third members of Lok Sabha should approve that bill, and it will go to Rajya Sabha. After getting two-third majority approval in Rajya Sabha, that bill will go to the President of India for assent, for approval, and after getting assent, the bill will again come back to the executive, that is cabinet, and the cabinet will finalize this, approve it, and send it to the for gazette notification. When that gazette if it is notified in gazette, it is said to be published. Publish, what do you mean by publication? If any particular issue is brought to the notice of third person or public, it is said to be published. Suppose I have written one book. That book, so long as it is within my hand, it is not published. When once it is brought to the notice of all people, that is called published. So when A makes a defamatory statement about B, both of them exchange any defamatory words, there is no any publication. When their defamatory words against other heard by somebody, then it gets published. So like this, publication means it is making publicity, bringing the matter to the notice of all concerned. That is publication. Then this is the executive, legislature, and judiciary. These are the three organs. So in this, on this concept of the doctrine of the executive, legislature, and judiciary, there is a one doctrine or rule or principle which is very important from examination point of view. This is principle of separation of powers, or the doctrine of separation of powers. Principle of separation of powers or doctrine of separation of powers. What is this? This principle of doctrine of separation of powers was originally initiated by, coined by French political philosopher Jean Boudin in the year 1526 in his book The Republic. The doctrine of separation of power is a very, very important topic. It appears in constitutional law, it appears in administrative law. Every lawman must have knowledge about this doctrine of separation of powers. According to this, this doctrine of separation of power was originally coined in the year 1526 by French philosopher Jean Boudin in his book The Republic. Later, this principle is at the credit for accelerating the significance of this particular doctrine. It is advocated and initiated and advocated by French jurist Montesquieu. Another French jurist, Montesquieu. In many books, this doctrine of separation of power is expounded or propounded, or the chief exponent of this principle is Montesquieu, the French jurist. That is the then. But originally it was coined in 1526 by Jean Boudin, a political philosopher. So, what is this? According to this principle of doctrine of separation of power, in any state, the government will be there. Every state will implement its ideals and goals through the organ of government. But this government will have three organs. The government will have three organs. Three authorities are three main pillars. They are the executive, the legislature, and the judiciary. The executive, according to doctrine of separation of powers, the executive must always discharge executive functions only. Secondly, the legislature must discharge legislative functions only, that is law-making functions only. Thirdly, the judiciary must discharge judicial functions only, judicial powers only. One organ or one authority should not interfere or intervene or encroach upon the powers or functions of another organ. For practical example, in a company, purchasing department is there, sales department is there, administrative department is there. Administrative department must all do only administrative jobs. Sales department must look into sales. Purchases department must look into purchases. So sales department should not do purchasing jobs. Purchasing department should not do administrative job. So you have to do your own work. Executive must do executive job work. Judiciary must do judicial work. Legislature must do legislative work. That is law making work. So this principle was coined by Lord Manso, French jurist. And then, according to this principle, one organ should not encroach upon this. So there is the question of implementation came for discussion. So some countries followed this, some countries never followed this principle, some countries partially followed it. The doctrine of separation of powers was followed or adopted by America, US, United States. The doctrine of separation of powers was followed or adopted, but it could not be failed. It could not be it could not be successful. It was found to be failed. In UK, in England, that is United Kingdom, Great Britain, the doctrine of separation of powers was not adopted, not accepted. The reason is there, like Lok Sabha and Rajya Sabha in India, there is House of Commons, House of Lords. In British Cabinet, British Parliament, lower house is House of Commons, like House of People in or Lok Sabha in India. The higher house is House of Lords, like Rajya Sabha in India, the upper house. So in England, the highest court of appeal is House of Lords. House of Lords. House of Lords was the highest court of appeal. So that is why in India the highest court is apex court, the Supreme Court of India. That means the House of Lords is the legislative body. It is discharging judicial powers. Means they did not follow the doctrine of separation of powers. In India, the principle or doctrine of separation of powers was followed partially. In India, all judicial powers are discharged by judiciary. Legislative powers are discharged by Parliament, central legislature, that is central legislature. Executive powers are discharged by executive, that is cabinet, headed by Prime Minister and President of India. Legislative powers are discharged by Lok Sabha, Rajya Sabha, headed by President of India. Judicial powers are headed by courts in India, headed by the Supreme Court of India. So these three powers are distributed, allocated among the three organs. But however, what this doctrine of separation of power critically enunciates, one organ should not interfere in the powers of another organ. So executive should not interfere in judicial powers, judiciary should not encroach in executive powers, executive should not encroach in legislative powers. This is the main condition, restriction. So this restriction partly maintainable and it cannot be strictly adhered to, because in India the judges of High Court and Supreme Court are appointed by the President of India, that is the executive head. That is the executive head. That is the Ministry of Home Affairs on the recommendation will make a proposal, and the President of India, with the consultation of the Chief Justices concerned, appoints High Court judges. Similarly, Supreme Court judges are appointed by the President through cabinet proposal and with the recommendation of Chief Justice of India. Like this. So, executive is encroaching upon the judiciary. No, the so-called executive interferes in judiciary at the time of appointments. Now, to confer independence of judiciary and to confer security of tenure to the judges of High Court and Supreme Court, so that they will be able to discharge their pure and impartial justice, the High Court judges and Supreme Court judges are appointed by the President of India. But though the President of India appointed them, President of India has no power to remove them. But the power to remove is in the hands of legislature only, that is Lok Sabha, Rajya Sabha. If any High Court judge or Supreme Court judge is to be removed from service, he should be removed by the process of impeachment. Impeachment in Lok Sabha and Rajya Sabha. The Parliament alone is having power to remove. Since previously Justice Ramaswamy, the Supreme Court judge was there long back. There were some corruption charges, and the impeachment move was initiated against him, but the impeachment move could not be materialized, and he was not dismissed. So this is the procedure. For appointment, in judiciary, executive is interfering at the time of appointment, legislature is interfering at the time of removal. Similarly, President of India is executive. For appointment, he is elected by members of Lok Sabha and Rajya Sabha, and also members of the Legislative Assembly. He is appointed by the members of legislature. So then the legislature is interfering in appointment of President of India. Similarly, for impeachment of President also, these members will have power to remove him. So similarly, executive, legislature and judiciary. So suppose the parliament can be dissolved. If parliament is to be dissolved, and the executive, that is the president, has the power to dissolve the Lok Sabha and Rajya Sabha, and he can declare emergency, and he can conduct a call for elections and everything. So in India, though we are following the principle of doctrine of powers, and we could not, it is partially adopted in India. So this doctrine of separation of power is an important topic from constitutional law and this constitutional law and administrative law. Every student must have knowledge about it. There is another important topic, is one more important topic every law student, law graduate must know, that is Locus Standi and public interest litigation. Locus Standi and public interest litigation. What is Locus Standi? What is public interest litigation is very important to note. And this topic you study in constitutional law and administrative law also. Locus Standi means a person who has right alone can go to the court. If one whose right is affected alone can go to court is Locus Standi. Any member of the public can go to court is public interest litigation. So these two concepts are there even today. Locus Standi is a strict principle, public interest litigation is a strict principle. The Locus Standi is a traditional rule. Like, for example, in law of contracts, you study cause of action, stranger to contract. In a contract, there are two parties, A and B. Contract, suppose contract of sale. If A fails to sell, the purchaser can sue seller. If the seller fails to sell, purchaser doesn't purchase, seller can sue purchaser. Seller doesn't sell, purchaser can sell. So if this party fails his contract, breaches the contract, other party can sue. If other party fails to breaches the contract, this party can sue. The aggrieved party in a contract will have cause of action to sue the other. So, but anybody other than parties to the contract are called stranger to contract. Suppose I entered into a contract with some builder. That builder has breached the contract. Then I want to file a case. But I am feeling guilty. So builder is a very rich man. If I file a case against him, I cannot get justice. On the other hand, I lose money. But my wife or my son will encourage me to file a case. But no, it is not good, I keep. But my wife or my son takes initiative and files a case. Either my wife or my son will become a stranger to contract. This case will be dismissed because I alone will have cause of action to sue the other party. Neither my wife nor my son cannot sue because they are stranger to contract. So this topic is there in section 25, clause 1, 2, 3. There are so many exceptions are there. Stranger to contract can sue, but that is different. Now coming to the point. Here like that, Locus Standi, public interest litigation. The traditional rule is Locus Standi and the public interest litigation is a recent concept. Here, suppose the government of India passed a GO or there's some executive action, or the government of India or state government, whatever it may be. If any executive action is there or legislative law is there, if the suppose a law is passed by parliament so that the doctors should not do practice, should not do private practice. Generally, it is outside the out of law. Doing private, the government doctor doing private practice is strictly prohibited. But if any law is passed affecting the interest of doctors, doctors alone will have locus standi to challenge it in court. Similarly, the government has passed a resolution by the maybe GO or any law restricting the retirement, the age of superannuation. Suppose the government has passed a law and confining service to 55 years, and those who are beyond 55 years get retired overnight. Then the government employees will have locus standi to approach the court. Then similarly, the private employee should not. But if any executive action is there or legislative action is there, any law is there, a government order or law affects the particular class of individuals, that particular class of individuals alone will have locus standi to approach the court. Then others, suppose the law or executive order causes damages, affects the interest of doctor, engineers cannot go. If it causes damage to engineers' interest, teachers cannot go. It causes damage to teachers, government employees should not go. Like that, the person whose right is affected alone can approach the court, others should not. So these are so many topics. Now, what is public interest litigation? The public litigation is recent law. What is this? In India, some time back, India was a developing country. Earlier, India was an underdeveloped country, poor country. In the latter, it is brought under the list of developing state. Now, our India is having with tremendous growth and development in all spheres of life. India is going to be one of the advanced countries in near future, and our India has occupied a wonderful position among the advanced states, and India now today can be regarded as one of the advanced states, rich countries. But whatever it may be, now Indian population of India is increasing day by day. So this question, dear children, you hear me carefully. Since the date of my childhood, I had been listening to this point. The population is increasing day by day. Overpopulation. When our Indian population was 70 crore, there was a serious problem. The government exhibited serious problem about overpopulation. At the time when I was a child, the family planning was introduced. For the doctors, government doctors were threatened by the governments to show minimum number of cases, otherwise their promotions were stopped and their increments were deducted. In some countries, some places, the doctors has operated unmarried people also. These were the cases long back. And now in recent past, actually the land is we have unlimited land, but for the exploitation sources in those days were very limited. But now even waste land is getting exploited like anything. Today, earlier there was unlimited land, it would not be utilized. For example, there is a land, 1 acre is not even 1 lakh, 1,000 rupees or 1 lakh. But if any city is constructed there, that 1 acre land is made crores of wealth. So when few thousand crores of loan was payable to the World Bank, the people were discussing how our India would be able to clear the loan of few thousands crores of loan to the bank. Today, even individuals are having thousands of crores and lakhs of crores, because the soil, the Indian soil has been developed. So what constitutes rich or poor in a particular country? So It depends upon the per capita income. This is a common sense point. You please make note of it. How we come to a conclusion that a particular country is rich or poor? Country is rich or poor in the sense on the territory of the country. What is the income from agriculture, agricultural products? In olden days, agriculture was taken up on traditional methods. Today, agriculture is undertaken on scientific methods. And the agriculture cultivated land is getting expanded day by day. So that is why the output in those days was very limited. The output from agriculture is getting improved day by day by using the fertilizers. And that is what constitutes national income. Output from income from agriculture. Next, income from industrial sector. Once upon a time, the factories were very rare. But today, everywhere factories. But factories are coming even in industries are coming even in residential areas also. There are so many pollution cases. We are witnessing so many pollution cases also. Once upon a time, the industries which were located in the outskirts have become now central point of the city. Because the population is increasing, city is increasing. Once upon a time, the so-called industry which was away from the city has become heart of the city today. So the pollution problems have started. So that is why the output from income from agriculture, income from agriculture, income from industries. Next, income from forests. Forest, we have lot of forest wealth. Sandalwood is there. Wonderful trees are there. There is a lot of wealth I cannot explain in words. So that is the forest wealth is there. Next source of national income is human resource. Suppose human resource. What do you mean by human resource? If the country, everybody is a talented man, everybody suppose doctor. One doctor is there, he undertakes so many cardiology operations, he earns 1 lakh a day, few lakhs a day. So then a gynecologist earns 1 lakh a day, few lakhs a day. Like this. So every individual, his income is less and income is more and expenditure is very less. The surplus income will be a wealth of the nation. So if an individual earns more and spends less, he is an asset to the country. If an individual income is more, income is less, expenditure more, he is a liability to the country. So the income from forests, income from agriculture, income from industries, income from human resource, individual service, all put together, national income. This national income is divided by population. We arrive at average. That average is called per capita income. If that per capita income is compared with standard per capita of US dollar, if it is above that per capita, that state is that country is declared as a rich country. If the per capita is less, it is declared as wicked. For example, in a common sense, in one family, one man is earning, 10 men is eating, 10 people are eating. His salary is 10,000 and 10,000 all 10 people have to survive. Then the average income is some 1,000, less than 1,000. But in some family, wife, husband, children, 4 are employing, everybody is earning 2 to 5 lakh salary. That family per capita income is more. So that is rich family. Like that, that family and this family, we are comparing. So the rich country, poor country also can be compared like this. For example, America is many times more than India. But the population is very limited. But the resources are unlimited. That is why America is enlisted as one of the richest country. But there is no enough population in America to utilize the resources. That is why America is able to accommodate so many countries, UK, India, Pakistan, all countries in the world. America is able to accommodate because they have unlimited resources. In order to make use of the unlimited resources, America must invariably, certainly, depend upon the surrounding countries. Otherwise, there is no other chance. So it is inevitable and incompatible. America must depend upon the population of the surrounding countries. to exploit the resources. So this is the position. Now here, Locus Standi and public interest litigation. When the population is increasing, litigation also is increasing. But here in India, the people are very fearful to go to the court, because in India, may the above middle class people and above middle class people, poor people are more. The percentage of poor people, below middle class people, and just above middle class people is more in India. Rich people are very limited. Even rich people are also today are fearful to go to the court, because there is a lot of delay in litigation. In UK, for small reason, power cut for half an hour, they go to court. In India, in cities, advanced cities, power cut is there for whole day, nobody will go to court. They go for generators and alternative arrangements. So they suppose if they pay banyan or cotton is defective, government is defective, they go to court. These points I am telling you out of my bookish knowledge. I have gone through some textbook while dealing with law of torts, and the law of torts is well developed in those advanced states like UK, US, but it is not well developed in our country like India, because for small reason they go to courts. The cases are decided quickly, but in India, even for serious cases, we are not able to go to court. In movies, we are witnessing, in family, one man is killed, they don't go to court and police station, because if they go to police station, two more members in the family will be killed, or all family members in the family will be killed. So that is why they are fearful to go to court. Mostly in our Telugu, Tollywood movies, we are witnessing that type of incidents. So similarly, there are so many rape cases. How many rape cases are taking place? How many rape cases are reported? But very few report cases. But because in some cases, parents think that if we exhibit this, what happens, whether the culprit is punished or not, we cannot say. There are so many rape cases, culprits were acquitted with the strength of efficiency of the public defense lawyer. They would able to escape from the clutches of bar. So there are so many events. Some great criminal lawyers means they can save the convicts. So another thing is, this is one thing. So now when population is increasing, cases are increasing day by day. In India, in a country like India, for serious matters, people are fearful to go to court, because the cost of litigation is very expensive. Lawyer fees are high, court fees are high, there is inordinate delay, they will not be able to go to court again and again. These are the problems. In India, because this inordinate delay means due to so many reasons, in India, we don't have courts and judicial officers commensurate to the population. So the population is unlimited, courts are limited, judicial officers are limited, revenue is limited, so many problems. That is why the Indian government of India is not able to provide a sufficient number of courts and sufficient number of judges, and they are going for alternative methods. Executives are given power to handle judicial matters. For example, commissioners of labor who do not have law degree, who are not the judges, real judges, they are asked to take up some cases. So as such, labor courts, industrial tribunals, such things have come. And if the judgments given by the executive heads are found to be incorrect and cause damage to interest of an individual, the party, the aggrieved party can approach the courts. For that purpose, the administrative law is introduced. So like this, so here, when a middle class man, educated man, rich man is unable to go to court, how a poor man will be able to go to court? Suppose in so many towns and cities, in outskirts, poor people are, slum dwellers are there. They are living. Those people do not have drinking water facility. Nobody is there. But they are suffering from mosquitoes nuisance. They cannot go to and report anybody. They cannot go to court. But any public spirited man like a law student or a veteran advocate MC Mehta in Delhi files a case, then that matter is it becomes public interest litigation. So when any individual in the country, whether he is a common man, whether he is an individual in the society, whether he is a law student, law graduate, or lawyer, whoever he may be, one can bring the public issue to the notice of the court for justice. That litigation is called public interest litigation. For example, in a city, there is a pollution problem is there. In Delhi, there is a vehicular pollution problem. For a vehicular pollution problem, MC Mehta, a lawyer, filed a petition in Supreme Court under Article 32. So, similarly, in Ratlam municipality case, there was a lot of public nuisance. The maintenance of canals, public canals, drainage, everything is dirty. In Ratlam municipality case, in Ratlam is the town, and there was a lot of indecency in that particular area. But the case was filed by public interest litigation is filed in local court under section 133 CRPC. Suppose if any public spirited man, he may be law student, law graduate, or member of the public and member of the social organization, can fight for the public cause. Suppose there is a public nuisance. Suppose there is one Gramford, continuous Gramford recording is there in some church or some theatre for their commercial purpose. But he can move this matter to the court. He can file a case under section 133 CRPC, or he can file a case under section 226 in High Court. He can file a case directly under section 32 of the Indian Constitution. 133 CRPC in local court, first class magistrate court, or article 226 in High Court of any capital city, or under article 32 before Supreme Court directly. So that petition is called public interest litigation petition. So for filing the petition, there are so many court formalities, but in India, there are so many cases. A postcard was treated as public interest litigation. A letter was treated as public interest litigation. A telephonic talk was treated as public interest litigation. The concept of public interest litigation was initiated for first time in some cases there, I forgot, but it is developed. It witnessed a new dimension in Gupta's case in 1980s. That is judge's transfer case. Subsequently, on public interest litigation, there are hundreds of cases, thousands of cases are there. One of the important cases is vehicular pollution case, Delhi, filed by MC Mehta. Ganga pollution case filed by MC Mehta. Ganga pollution case, Ganga's water is getting polluted, and through what cities the Ganga water is getting polluted. So for that purpose, public interest litigation case was filed. For that, the government, the corporation of the Kanpur, the municipal corporation was given so many guidelines to remove the pollution from Ganga. Similarly, Kamalnath case is there, what not. There are thousands of cases on public interest litigation, but these case law reveal that for purpose of this moving this public interest litigation petition, the procedural whether the case is filed procedurally by filing petition as per the rule of law, it is considered by as public interest litigation petition, and court is giving direction. And after Bhopal gas tragedy case, within 1 year, Bhopal gas tragedy case took place in late 1984. That is early 1985. Within 1 year, 1986, Serum Foods and Fertilizers, one more tragedy took place, and case was filed by MC Mehta on that, and it was considered. Similarly, there are some cases, even a postcard was treated as a public interest litigation. A letter was treated as public interest. In Rodal Savas state of Bihar, a postcard was sent to the court, Supreme Court. An acquitted person was detained in prison for more than 14 years. Acquitted means he should be sent home immediately, but he was not released. But after acquittal, that man is detained in prison for more than 14 years. When a letter was addressed to the Supreme Court, then Chief Justice of India Chandrachud direction to the government of Bihar for his release immediately, and also asked the government to pay compensation. So this is what is called public interest litigation. Public interest means any public spirited man can approach the court for justice. Similarly, one more thing is judicial activism. One more point, these are the general topics. So this judicial activism topic is quite obviously you come across in seminars and everything. What is judicial activism? Judicial activism means, suppose any judgment is there, if any case is there before the court, the judges must interpret that law very carefully. In order to give judgment, the judge will take the help of legislation or custom or precedent or some other source, principles of law, justice, equity, good conscience. Suppose when a case is there before the judge will decide the case on legislation. Suppose according to 300 it is murder, 302 punishment, life imprisonment or death judgment. According to section 5 Hindu Marriage Act, degrees of prohibited relationship, this marriage is invalid. That is the thing. So according to 376 it is rape, punishment for rape. So the judge is taking the help. According to section 9, decree of restitution of conjugal rights is given. According to section 13 of Hindu Marriage Act, divorce is granted. According to section 13A, divorce by mutual consent is granted. Like that. So the judges will give judgment after hearing from both the sides on the principles of legislation. Legislation is one source. Second source is custom. Sometimes the judges will give judgment basing on the custom. For example, degrees of prohibited relationship. If any marriage, Hindu marriage takes place, if a marriage in Hindus take place between any relation of degrees of prohibited relationship. What is the degrees of prohibited relationship? A man cannot marry his own mother. A woman cannot marry his own father. A woman cannot marry his own brother. A man cannot marry his own sister. Similarly, a man cannot marry his sister's daughter. Similarly, a man cannot marry his aunt's daughter, like that. There. But some relation, unless the custom or usage so permits. In South India, a man can marry his sister's daughter, elder sister's daughter, because brother-in-law is outsider. Outside blood is involved in that. So that is why it is a custom. But in South India, a man can marry his elder sister's daughter, but in North India, in other so many religions, that marriage is strictly prohibited. Though it is as according to section 5 Hindu Marriage Act, that particular marriage brought under the ambit of section 5 Hindu Marriage Act, degrees of prohibited relationship, according to legislation, that marriage should be declared void, illegal. But if the custom savage is there, means any court wants to unite the couple rather than separate the couple, and then court gives priority to custom and declares the marriage valid. So like that, sometimes we cannot say that whichever is more important, we cannot say. Sometimes court will take the help of, ultimately the object of the court is to deliver pure and impartial judgment. Sometimes the court follows legislation, sometimes the court follows custom, sometimes the court follows precedent. Precedent means the judgment given by the court. Suppose the judgment given by Supreme Court should be followed by all high courts. Suppose there are some cases, some landmark judgment is given by the Supreme Court. For example, Vidyavati was the state of Rajasthan. What happened was, Vidyavati husband was died in a collector jeep on official trip. Then she approached the government, Rajasthan government, for compensation, husband death compensation. But when government is liable, when government is not liable, there is no any law. The law is uncertain. So the government, Rajasthan state government followed 1860. 1860 means more than 1960. 40, more than 150 years old, outdated sovereign non-sovereign dichotomy coined by Justice Peacock in P&O Peninsular Oriental Steam Navigation case that followed, and sovereign non-sovereign dichotomy, no liability. They said that as per sovereign non-sovereign dichotomy, the state government is not liable, the case was dismissed. This innocent woman went to Supreme Court. Then the judge was Chief Justice Sinha. Then Chief Justice Sinha did not take into consideration. In no custom, no rule, no law, nothing else. When an aggrieved woman having lost, when there is a widow, she lost her husband in an accident, and approaching the court, approaching the government for compensation, Having lost her husband, she is deprived of her livelihood and approaching the court for a livelihood. You are taking the sovereign, non-sovereign, all this nonsense. What? It is illegal. It never referred anything and directly directed the Rajasthan government to pay compensation. That is what is called judicial activism. That is what is called that is the power given to the that is what is called review power, inherent jurisdiction, ends of justice. So when a case is to be decided, sometimes the judge follows legislation. Sometimes the judge follows custom. Sometimes the judge follows precedent. That is judgment given by another court, the superior court. It will follow. That is precedent. Judgment by Supreme Court should be followed by all the courts, and judgment given by Andhra Pradesh High Court should be followed by the lower court. That is called, in same case, similar facts and circumstances. That is called precedent. Then another thing, equity, principles of equity and natural justice. Justice, equity and good conscience. But what is equity, principle of equity? There are some rules. Minor has no liability. Minor has no liability. So minor, when a minor enjoys some property, he morally has an obligation to pay the money. But as per law, a minor is not competent to contract, he need not pay. That is law. As per law, minor need not pay. As per morality, as per principles of natural justice, he should pay. For example, I have borrowed some 1 lakh rupees from my friend. I executed promissory note. 3 years elapsed. 3 years elapsed. When the promissory note is invalid. Promissory note is invalid. Law, if we speak law, according to law, I have no obligation to pay. If my friend approaches the court on the principle of limitation law, the case will be dismissed, I need not pay. But I must have morality and principles of natural justice. I borrowed from 1 lakh. I borrowed from him 1 lakh. So I could not, he did not demand me, I could not pay within 3 years. But I should not take the advantage of that limitation period and evade the liability. As a man of morality, as a man of sincerity, I must have. That is what is called the principles of equity or natural justice. That sometimes it is followed. So, in order to provide pure and impartial justice, from lower court to the apex court, some laws are provided, some special provisions are provided in the Code of Civil Procedure under section 148 to 151A. In criminal law, similar provisions are provided. In High Court, High Court is given such powers under Article 226. Supreme Court is given such powers under Article 32 and 136. What the court feels right, what the court feels justice, what the court feels proper, it can, in the interest of pure and impartial justice, whatever judgment is given by the court, that is final. That is what is called judicial activism. In India, in so many areas, the laws are not there. Laws are not there. In so many areas, law is not clear. This lawlessness and uncertainty law is getting cleared by the court by activism, by interference of the court, by delivering landmark judgment. The type of activism or initiative taken by the High Courts and Supreme Court to provide appropriate relief to the aggrieved party in order to provide pure and impartial justice is judicial activism. So, provided that is a very decent welcoming feature, provided there should not be, the independence of judges should not be affected by some other forces like political interference or other, so that it's a welcoming feature to confer independence of judiciary, so that they will be able to deliver daring, dashing, landmark judgment without any fear. So, thank you very much for friends for your patient hearing. Thank you all.